I'm Bill Oughton of Oughton Claims Management.
I'm Chantal Roberts of CMR Consulting, and welcome to the Art of Adjusting podcast.
Today, we're going to talk about life as an insurance adjuster from the perspective of property, auto, liability, or workers' compensation adjusters. Our goal is to bring interesting topics in the world of claims adjusting to people who are working as an adjuster now and to people who are considering a career as a claims adjuster.
Okay, good morning. Our guest today is Quentin Brogdon, and he was recommended to us by Nancy Germond of the Big I. Uh, Nancy had attended his lecture and said that he was a fantastic speaker and would be a great guest for the show. I do want to point out that you will see that there's only Quentin and me here because Bill, being an independent, has to run out and do some adjusting work. I mean, silly insurers making us do our work and stuff. I mean, that's not any fun. But yeah, so it's just Quentin and me today, and we'll be talking. I want to tell you a little bit about Quentin. He is a partner at Crain Brogdon. He is a fellow of the invitation only International Academy of Trial Lawyers, a fellow of the invitation only American College of Trial Lawyers. I think you were vice chair of Texas. And a fellow of the invitation only International Society of Barristers. So basically, you want him on your party list because it's all invitation only, basically. And so, one of the reasons why, besides Nancy's suggestion, that I wanted to have him on as a guest is that Quentin is, of course, board certified and as a personal injury trial lawyer and in civil trial advocacy. For newer adjusters, he represents policy or third-party claimants, and he can give us an alternate viewpoint that we as adjusters are not used to seeing and hearing. And just a fun little fact about me, I was telling Quentin about this before we kind of quote unquote started recording or going live, whatever, is that when I was a baby adjuster, I was living in Dallas. As you can see, it's so hard to do the whole, backwards thing. But anyway, there's a Baylor, if you're watching via YouTube, there's a Baylor University, diploma in the back. Of course, it's in Waco, Texas, about an hour and a half south of Dallas. I lived in Dallas for a little while, became an adjuster, and I had this fear of going into like a bar or a restaurant by myself. And so one New Year's Eve, my New Year's resolution was I'm going to conquer this fear. I found a bar, became a regular where I befriended, or I guess a plaintiff attorney befriended me, and we would have these fantastic conversations over a couple of beers. And it was so much fun because it really kind of, we dropped the whole posturing aspect that we had to have when we were at work, and like, I'm the big bad insurance company, and you're the big bad attorney, and yada yada yada. And so it really helped me understand y'all's point of view, and that's one of the things that I'm hoping Quentin can help us with today. So welcome, Quentin, after that long introduction.
Good morning, Chantal. Thank you for having me on, and I'm glad to hear you consorted with the enemy once upon a time. We really are in a symbiotic relationship, the plaintiff's bar and the insurance and adjusting industries, because, I mean, many of us, we're started out on one side or the other. I started out doing insurance defense work for many years before the wizard gave me a heart. And, so I understand, I think it's better for each side if you kind of get into the head, if you will, of the opponent in the case, and you adopt a professional approach and kind of always be looking at things through the eyes of the potential jurors going forward. That's really what matters more than any ideology, whether it's a defense ideology or a plaintiff's ideology. There are plaintiff's attorneys who've never seen a case that wasn't worth millions of dollars, no matter how spurious. And then there are insurance adjusters and claims managers who've never seen a meritorious case, no matter how truly meritorious it is. And so I think you always have to be guided by the lodestar. What are jurors going to do? 12 jurors, 6 jurors, however many it ends up seeing at the courthouse with these facts.
I totally agree, and I'm not necessarily sure. And again, whole different topic that we are going to be talking about is about the training of adjusters, and I'm not necessarily sure that insurers, carriers really train our adjusters for that kind of thinking anymore. Being that and I used to tell my adjusters when I was a claims manager, how many, or I'd ask them, I'm like, how many sides of a coin are there? And they would all say two. And I'm like, nope, there are three. If you think about it, heads, tails, and then that side that we spin the coin on. And so you've got his version, her version, and then they meet somewhere in the middle. And so I totally agree with you. And I am so incredibly happy that you're here to give us some of those things that we can consider, because I know as an expert witness, in fact, I just signed on a policyholder with this policyholder attorney yesterday, that I've actually learned quite a bit from them. I'm like, oh, yeah, maybe you're all right. And of course, contract of adhesion. We've talked about that in the past podcast. Contract of adhesion. If there's a ambiguity, we got to give it to the insured. Okay, so anyway, let's just jump in.
Sure.
So one of the things that Nancy had told me about the talk that she said that she saw you in was the 5 things that will push you into litigation and how to avoid them. And by you, of course, Quentin, you are talking about the carriers, the 5 things that will push a carrier or an adjuster or a file into litigation, and how to avoid those things. So, could you name off 1 or 2 of them, or all? Maybe you know all 5 of them. I have no idea. I never can remember stuff.
Well, thank you, Chantal. I was asked to make a presentation to the Complex Claims Seminar in Las Vegas this year. And in putting together that paper and that presentation, I sat down and I put on my insurance adjuster hat, my insurance defense lawyer hat, and also I used some of the insights I've kind of come up with over the years from the other side, from being a plaintiff's attorney now since 1998. I've been practicing law 34 years. My first 10 years, I was a criminal prosecutor and then an insurance defense lawyer. And so I've seen both sides, or 2 sides of the coin, and the third side as well, to use your analogy.
Mhm.
And in putting together the talk for the Vegas presentation, it occurred to me there were 5 things. You could break them, there are subparts, of course, that push insurance adjusters and claims managers into litigation that at least sometimes is avoidable and should be avoided. Of course, there are entities, whether they're insurance companies or self-insureds, who deliberately adopt a posture of, we're going to try everything for deterrence. Even if it's meritorious, we're going to make lowball offers, knowingly offer less than jurors probably more times than not are going to award, maybe 2/3 of the amount, hypothetically, on the premise that most claimants will bite at that lure. They will bite rather than going all the way to trial. They and their lawyers will accept less than the full market value, if you will, of their claims. So obviously that strategy can change what I'm getting ready to say, but assuming we're simply talking about claims that can be and should be adjusted based on the merits.
Right.
And even if you're adopting a preventative strategy of deterrence, I think you want, as a claims manager, always to have in the back of your head, well, what's fair? You want to start there, and maybe you deliberately lowball what's fair, but you can't lose sight, in my judgment, of what's fair, even though you may not offer what's fair. And what we've seen from both sides of the trenches, if you will, from the law side, law is increasingly becoming a business. Lawyers and law firms are increasingly motivated by advertising and the bottom line. It's not a noble profession to the degree it once was. We're also seeing insurance companies that increasingly are adopting a bottom line mentality. It's not about fair adjusting, it's about maximizing profits. It's not about taking care of even their own policyholders. It's one thing to disrespect and to lowball third-party claimants, but I believe it's a horse of an entirely different color if an insurance company is disrespecting and lowballing and not fairly adjusting claims made by their own policyholders that have paid premiums for years with the expectation that when they were in need, when they were vulnerable, their own insurance company was going to do the right thing and the fair thing. And so we've seen that from both sides, this creeping. It's more and more a business mentality. And unfortunately, what that breeds is a mentality of fighting, a mentality of distrust. The old etiquette, if you will, between adjusters and claimants and plaintiffs' attorneys has largely broken down.
Yeah.
On the big claims, for instance, airplane crash cases, for instance, medical malpractice cases involving a select group of insurance companies and lawyers, there are still vestiges of that old etiquette that remain. But on the day in, day out, particularly car crash cases, to the extent there ever was an etiquette of free and open communication, of respect and trustworthiness, I believe at least that is almost completely now broken.
Yeah.
So I think the task from both sides, from the lawyer side and from the adjuster side, is to try and break through that barrier of mistrust and lack of professionalism. When I have an adjuster call me on the phone and start berating or questioning or doing whatever, I deliberately adopt a counter approach of politeness and say, well, listen, I understand your point of view, but there's some things you may not understand or may not know about this claim. Let me show you. And that's my approach. And sometimes it works and sometimes it doesn't. But I think all of us just need to pause and take a step back when dealing with the other side. So that's kind of my preface generally on an approach.
Right.
Now, with respect to the specific 5 things, and we can get into the weeds on these, Chantal, when I made my list, I came up with the following 5 things that really impede resolving claims as early as they could otherwise be resolved. And here they are, no particular order. Failing to resolve claims early. In other words, failing to segregate claims that should be resolved early from those that may need to be and you may want to litigate longer term. Thwarting mediations. And there are ways that claimants, claimants, yes, of course, but claims adjusters and risk managers thwart mediations. And I see that. I suspected it was going on when I was on the insurance defense side, but now I'm often, unbeknownst to the claims managers and adjusters, their biggest ally, because I'm pouring cold water on a very upset client because the adjuster was late. The adjuster didn't show up. The adjuster said, oh, this needs to just be a half-day mediation, which can be viewed as a sign of disrespect. The adjuster comes in and begins making very low offers on a death case, for instance.
Exactly.
So those are the kinds of things I am having to fix, if you will, in many cases, unbeknownst to the adjuster who adopted a strategy that was not effective at a mediation. Ineffective approaches to claims, and there's a whole series of those that we can talk about in a minute. Ineffective use of motions for summary judgment. There are cases where motions for summary judgment should be filed. There are other cases where they're a waste of time and a waste of resources. And then there are other things that, the timing of when they're filed. There's nothing that makes a judge more upset. There's nothing that throws a wrench in things than the adjuster or the defense attorney waiting to the last minute, having a motion for summary judgment hearing, literally the week before a jury trial. What that means is all the work has been done on that case. The insurance company has paid its lawyer to go take all these depositions. The lawyer, the defense lawyer, oftentimes doesn't mind at all. Fine,
Well, they're getting
I'll
paid. They're getting paid.
Yes, the adjuster has to step in and say, I want a summary judgment filed, and I want it filed sooner rather than later. And that isn't done often enough. And so we can talk more about that. And then there are a whole series of common defense mistakes, whether they're strategies in adjusting or strategies in handling the case as you go along. And I compiled a list of those. So those are my 5 broad categories.
You know what? You have said so many things, and I've been over here nodding. If you're watching on YouTube, I am over here just nodding and saying like, "Oh my gosh, you are preaching to the choir." One of the things that you had said, and I mentioned this, and I think that it is a rather different viewpoint than what most adjusters have, is that treating our third party claimants the same way that we treat our first party claimants, being our insureds, we have to treat them the same, in my personal opinion. We don't deliberately lowball the third party claimants because they can, of course, turn around, sue the insured, and then the insured can then turn around and sue us for failure to settle within policy limits or whatever other kind of bad faith. Now, in Texas, you've got like the Mary Carter Agreement. It's called different things in different states, I believe. But, failing to resolve claims early. Bill and I talk about this quite a bit. And I would even object to insurers, even if they want to do that scorched earth ideology, which is what you were kind of referring to earlier, where you're wanting to take a stand and we're going to fight everything, whether it's meritorious or not. Scorched earth. There are certain insurance companies and self-insured people. We won't mention them. Email me and I'll tell you, because I don't want to get libel or slander or anything like that. And then Quentin would have to defend me and stuff. Anywho, but lowballing guys, period, don't do it. We, our job as claims professionals is to settle claims. That is our job. And it is to settle it for the correct amount. Now, the correct amount, I always call it like a speed limit. Just because we settle at the lower end of my authority or my lower end of what I value the claim at doesn't mean I'm quote unquote lowballing. Just because we settle this at the higher amount of that range doesn't mean that you got the maximum amount or whatever. It's more like a speed limit, a speed zone, because I don't know if a lot of people know this, but we do actually have speed zones. We see the speed limit, but every once in a while you'll see minimum limit 50 miles per hour, maximum 75 or whatever. That's a speed zone. That's what I'm kind of referring to. But anyway, do not deliberately lowball, period, even if it's a third party, because if you do, everybody's got to get sued. That runs up loss adjustment expenses, which of course runs up all of our premiums and just makes our files stay open longer. So what Quentin said, gosh darn it. So I totally basically agree. We are great big proponents of settling claims early. And, sometimes that is difficult. But if you have clear liability, meaning that the insured is responsible or negligent, we should hustle as the insurance company to move the file towards closure. Don't sit back and wait for the attorney to send the medical bills and records. Send them the authorizations. Sometimes they won't sign it. Sometimes the attorneys won't sign it. They prefer to spoon feed us. Fine. But send them the release of information often and early. Is there any other advice that you would give to adjusters about resolving a claim early? Like what they could do?
Well, part of resolving a claim early involves finding out about the claim and finding out what the claim is worth. Consider even an early focus group. Run it by some folks on particularly in a big claim. Some claims they fit into the cookie cutter mold, but if it doesn't fit into that cookie cutter mold, I just did a focus group 2 days ago in a case that was not a cookie cutter case. It had a unique set of facts, and I learned a lot from that focus group. So consider that. Treat claimants courteously. Keep your word to the claimant. You can't imagine how many claimants come to me. And the sole reason they're coming to a lawyer is the adjuster either promised to do something and didn't follow through, and or The claimant made a basic request. Hey, I understand there's video of this incident. May I have a copy? And the adjuster says, well, no. Our policy in handling these claims is we do not hand out video of the incident. Oh, and by the way, I want a bunch of stuff from you, claimant.
Yeah.
I want you to sign a release and I want you to give up your privacy in this, but I'm not giving you anything.
Right. Right.
So just beware of that. And you couldn't imagine either the number of times I hear about stories of evidence that's been destroyed. There was a video, and then I asked for it, and I'm told it doesn't exist. And then later, after I file a lawsuit, oh, here's the video.
Surprise. Yeah.
Yeah. So the
Yeah.
other thing you can do as an adjuster is provide reasonable deadlines.
Mhm.
I need to have this information in hand by this date. In Texas, one of the fights we have fairly consistently, because we don't have a law mandating otherwise, is finding out the amount of the insurance coverage. There's no law in Texas. I understand there are laws in many states that require and mandate the insurance company provide pre-suit
Mhm.
the amount of the insurance coverage to a claimant, a third-party claimant. We don't have such a law. So in case after case after case that I handle in the state of Texas, the adjuster says, well, my company will not allow me to produce and to disclose the amount of the policy. And so I'm filing a lawsuit. The insurance company is basically motivating and propagating unnecessary lawsuits against their insureds by failing to disclose a very basic and important piece of information, namely the amount of the insurance coverage.
Yeah.
And so I would recommend strongly that to the extent special dispensation can be achieved, to the extent an adjuster who works for an insurance company that will not allow that can go to that insurance company and say, here's what's happening. And that should be reconsidered. If the other side has problems, tell the lawyer that early.
Yes.
Here's the deal. You may not be aware, plaintiff's lawyer, but your claimant has a felony conviction. You
Mhm.
may not be aware, but the toxicology result for the night of the crash shows your claimant was double the legal limit in the state of Texas, or whatever it may be. You may not be aware, but your claimant has made 5 previous claims with similar facts. Don't play hide the ball. Show the plaintiff's attorney, and a respectable, honorable, competent plaintiff's attorney will say, thank you. And yes, I appreciate that. And I now agree my previous demand was too high.
Yes.
And let's try to get this resolved. Look at verdict reports, obviously, to try and figure out where things go. Acknowledge fault. You wouldn't imagine the number of cases I end up dealing with where the adjuster and later the defense lawyer persist in not acknowledging fault, not apologizing to the claimant at an early stage, even before litigation. And when the case is really about damages, it's okay to say, yes, we made a mistake. Yes, a jury's probably going to find that we're negligent, but the amount of damages you are asking for, Mr. Claimant or Mr. Plaintiff's attorney, are in excess of what we believe are fair and reasonable. Simply because we're negligent doesn't mean we owe you your full demand. And I see insurance company after insurance company, and I love it when this happens at trial because jurors don't like that. They don't like a strategy of contesting liability in a clear liability case. And generally, when a defendant or defense attorney at the behest or directive of their insurance company who's paying that defense attorney pursues that strategy, it backfires in my experience in case after case after case.
Absolutely. Yeah. No, again, I can't believe. I mean, one would think, and it's actually kind of funny. I wrote a book called The Art of Adjusting, and my mentor uses that book when he represents policyholder attorneys, and I think that that's absolutely hysterical because I am writing it for insurance adjusters, and it's not. I don't believe plaintiff leaning because what I am doing is the same thing that what you are telling adjusters and carriers to do. Stop messing about and settle the claim. Adjusters, what I would do in regards to like this video instance, that Quentin was talking about, because I've run into it. I have had carriers that are like, nope, that's our product, that's our insured's, information. We're not going to share it. And you as the insurance adjuster will ask your manager if hey, Quentin wants it, can I go send it to Quentin? And they will say no, along with the policy limits or whatever. And what you need to say to that supervisor adjusters is, okay, but here's the deal, they're going to be able to get it when they subpoena it in a lawsuit, so we can give it now and they can see our point of view, or they can get it later after we've spent a couple of tens of thousands of dollars in defense costs, raising our loss adjustment expenses, LAE. So what do you want to do, boss? And you know what? If the carrier still wants to live and die on that hill, that's fine. Be sure you put in your notes, I went to the boss and asked them, and the boss said no, even though, I mean, I would reword it, of course. But the point is, because by the time that I read it as an expert witness, I at least see that, yeah, y'all are trying, but it's more maybe a systemic issue. About the giving of limits, and real quick question on that, because I have always told attorneys no, because of the same thing that you mentioned. The carrier doesn't want to do that unless it is state law. And Bill would be perfect here because he's from New York, and I do believe it is law in New York, because he talks about it quite often. But I have never done it, and the reason I have never done it, and the reason I was told not to do it, was because of quote privacy issues, end of quote. Um, I don't. I mean, it's not necessarily HIPAA or anything. And again, it's something that you would get when you subpoena that information. Do you have a quick answer for that?
Yeah, I think it does a disservice to the insured not providing it. I think if insureds were told, and maybe the answer is you go to the insured
Mm-hmm.
and you get permission explicitly and you say, here's what's happening. They're asking for your limits. You don't have to consent to it, but understand this, Miss Insured,
Right.
you may get sued next week solely for the reason that the other side has requested and not obtained these insurance limits. So tell us, large insurance company, how you want to handle this. Most insureds, and I represented insureds and now I sue them,
Mm-hmm.
given the choice and the information, would say,
Give it
fine,
a
go
give
ahead
it.
and disclose it.
Yes.
Particularly when they receive the explanation that the minute the lawsuit is filed, it's going to be discoverable. The other
Mm-hmm.
side's going to get it. And being sued isn't fun. Being sued means more probably than not, this whole process is going to go perhaps another year or two, or even three, beyond what it otherwise might, if we can resolve this claim now.
Yes.
Most insureds do not want to be sued. Most insureds, I spoke to one the other day, a family friend who's being sued, and it's a terrifying experience if you're not a lawyer. You don't understand what insurance will cover and whether insurance is going to pay for a lawyer for you and what your personal exposure could be, et cetera, et cetera. And I just had that long conversation yesterday with a family friend.
Mm-hmm.
So I think it is a non-issue. I think it is born out of an insurance company approach that says, well, if we give those tricky, sneaky plaintiffs' attorneys the limits of the policy, then it's going to be harder to settle the case.
Right,
And
because they're going to want that amount.
I would submit to you, the answer is you just say no. The limits are 100. The most we'll pay you is 30, hypothetically.
Right.
So, well, but your limits are 100. So the claim isn't worth 100.
Right.
So, and that's kind of a segue into mediation if you want to talk about it.
I'd love to, because I also wanted to talk, just real briefly, another thing that you mentioned, and another thing that Bill and I quite often talk about, and I talked about it in my book. Give the information. You're talking about civility and everything. By goodness, adjusters, a lot of you have licenses. Y'all are licensed individuals. This means that you are a professional. Now, in some states like Kansas, Missouri, Colorado, we don't have licenses. In some states, Arkansas, Oklahoma, Texas, we do, but regardless of if you have a license or not, you are a professional. You wouldn't act that way, or you wouldn't expect your plumber or your doctor, who are also licensed professionals, to act this way. So you don't act that way to this attorney, even if they're acting that way to you. Quentin won't do that, but whatever. But let's talk mediation, because I don't think a lot of adjusters, especially new adjusters, know much about mediation and how they should be acting in it.
Well, I alluded to this earlier. There are untold numbers of mediations over the years where I've had to be the ally of the defense attorney who adopted an unnecessarily in-your-face approach. I'm thinking of one case specifically where the daughter of a family had died, and there were arguments to be made on the defense side that the family who was in proximity during a party during which this person consumed alcohol had not sufficiently stepped up and assisted in cutting her off or whatever. Those arguments were there to be made, but the way the arguments were made in the mediation was so over the top that I actually had to step in, and the case ended up getting resolved near the amount that the defense lawyer and I had privately discussed way back when. But the clients were quite upset, and it was just a misfire of epic proportions. The case went on another year. Defense costs for the insurance company continued to mount and accumulate when it could have been potentially at least shut down at a mediation 1 year earlier.
Right.
So the approach is important. You can apologize, you can be civil, and you can say no with a smile as an adjuster. You don't have to, and you can instruct your attorneys. Sometimes what happens is the defense attorneys hijack the process. I can't help but suspect. They hijack the process in that they don't really have an incentive in shutting down the claims early because they're billing by the hour. The minute it's shut down, then the billing stops. So it is very important for the adjuster to be proactive, to monitor what is going on, not to simply sit in awe and in deference of their defense attorneys, to ask hard questions. Have we considered this? What's our budget? What's your plan here? Why are we taking these 10 depositions? Do we need those to evaluate the claim? Have we taken proactive steps to reach out? And sometimes at mediation and in the negotiations, particularly younger adjusters are afraid of appearing weak. So for instance, you come to a mediation as an adjuster and the other side is demanding $1 million on a claim that's worth 100,000, hypothetically. And so sometimes, there are two approaches in dealing with that. One is to try and school the other side, the plaintiff side, and to retaliate in essence by saying, oh, you're at $1 million. Here, we're at $1,000.
Exactly. Yeah.
On this serious injury case, because you're at $1 million and that's not reasonable.
Nope.
So that's an approach, and you can do that, but just know that you're thwarting, and maybe you want to thwart. You're thwarting an early settlement. I think the more effective approach is an insurance company and an adjuster who comes into the mediation and basically has adopted the position, here's what we're willing to pay, 100 grand. They go through the mediation and they negotiate as though the other side is not even there. Here's our offer. You're at $1 million. Okay, now you're at 990. Here's our second offer. Here's our second offer. Oh, and by the way, we're almost done. Here's our final offer. And you might stop at 90 or 85 when you really want to pay 100. But then a couple of things potentially can happen. The mediator can go and work on the plaintiff's attorney. And sometimes what's really going on, unbeknownst to the adjuster, is the plaintiff, not the attorney. The attorney is saying the case is worth 100. But the client, the plaintiff, is saying, no, I want $1 million. I want 700 grand or whatever. And so it can be very beneficial to the plaintiff's attorney to have that money on the table so that there's not been a disrespect of the plaintiff And the adjuster, the mediator can then talk to the plaintiff and say, look, this insurance company is at 85 in my hypothetical. Perhaps I can get them to 100, but they're not going to pay you anything near $1 million. And they haven't disrespected you by coming in here and offering you 1,000 or 5,000 or 10,000. And so sometimes there's a fear of appearing weak by putting your cards on the table from the defense side. And the more experienced adjusters I deal with in the larger cases are much more willing, because largely oftentimes, sometimes it's not the adjuster's fault, by the way. Sometimes the insurance company says, here is $30,000 on this case. We know it's worth 100.
But
And
we're only giving you
call us-
authority.
Call us from the mediation if it looks like it's getting close. And then the plaintiff is at, in my hypothetical, 950,000 or whatever still. So the adjuster says, well, I'll never get fired in this scenario. Why should I make this phone call? And everything is stuck. And so I would humbly suggest that more times than currently occurs, you send, as an insurance company, your adjusters with sufficient authority. You trust your adjusters. If you don't, hire new adjusters. Give them the authority. Let them put it out there. And then sometimes there's an alchemy going on behind the scenes where a week, a month later, the mediator makes a proposal, or the plaintiff calls his or her attorney and says, well, they had offered this. I think I'm ready to accept it. But if you offered 30 and you quit, you don't allow that to occur.
Right. You've said, again, so many important things. Let's talk about real quick, for people who don't know what a mediation is. And what happens is sometimes the courts will order a mediation, but sometimes we will all agree on a mediation, the plaintiff side and the defense side, to pick a person, usually a retired judge. And first of all, we all meet in one room. As the adjuster, I'll give my point of view. Sometimes you, Quentin, will give your point of view, or sometimes you'll let your client speak about how it has impacted them or whatever. Then we all go our separate ways. I sit in one room and you and your client sit in another room, and the mediator will go back and forth. And the mediator basically says, here's their, points. This is why you need this, or this is why they want 100,000 or 900,000 or $1 million, or, whatever. And then I'll go, yeah, no, that's not happening. I've got 30,000 or whatever. And then the mediator will go over to your side, your room, and go, okay, this is their points. And one of the things that you had mentioned, and gosh knows, again, guys, as adjusters, I have taken the plaintiff attorney to the side and said, can we do a mediation? I sense, and I know that you, out of loyalty, cannot admit to this, but I sense that you have an out of control client, and you've got a client who is looking at the billboards, and seeing dollar signs or a Christmas wish list or whatever. Can we go to mediation? And it is often that third party, being the mediator, who talks to that out of control claimant and can reason with, like, now here's another person other than their attorney saying, yeah, this is not as worth much. But adjusters, you've got to go in with some good faith, because I'm going to tell you, I have seen, as a claims expert, or as an expert witness, so many times that adjusters or insurance companies get sued for going into mediation with $1,000 in authorization. Dude, come on now. We all know defense cost more than $1,000. Stop it. That is bad faith. You are not protecting the fiduciary duties of or the fiduciary interests of your insured. You're not protecting your insured by walking into a mediation with $1,000. Yes, it feels good to sucker punch the guys in the throat. Absolutely. I get it. I totally get it. But it's not in good faith. And so don't do it. Just don't do it. I would love to the whole purpose of this podcast, Quentin, is to put myself out of business. You probably don't want to put yourself out of business, but I would love to put myself out of business. So yes, everything that you have talked about, again, as younger adjusters, we don't have a lot of pull to go to our to go to our supervisors and go, yeah, I'm going to need that whole 100,000 to walk in. But maybe you talked to defense counsel and you have defense counsel tell the supervisors they need to, give the whole full 100,000 to settle or whatever. So absolutely, I totally agree with that. There's other things that we talked about, the ineffective approaches to claim settlement, and I think that that's one of them. When you are doing that, common defense mistakes. You had mentioned one thing, and this drove me up the wall when I was an adjuster because I would see it like originally. I would come up and my authority was 100,000, for example. They would file suit. Well, now we have defense costs that we can burn through. And I can add that to the kitty, so to speak. So if I suspect that defense costs, even if they're in-house counsel, there's an envelope for in-house counsel. Even if in-house counsel is going to be 50,000 or whatever, now I can settle for 150 if I want to. Is that whole defense person, and you talked about it, not wanting to settle because they are getting paid by the hour. And not to call out my defense counsel people, but they do have a vested interest, just like the plaintiff counsels have interest to get a higher settlement because they have a percentage. They take 25%, 33%, whatever percentage, you know. So defense counsel also has a vested interest to let it go. Would drive me up the wall that they would go all the way through uh, depositions before deciding to settle. And all the while, as an adjuster, I'm over here screaming, we need to settle. Stop spending money. Let's do that summary judgment. Do you have a comment since you've worn both hats, but you did mention, correct use of motion of summary judgments, defense counsel mistakes, whatever.
I think there's a way, Chantal, for the adjuster to not have an adversarial relationship with the insurance defense counsel or the self-insured counsel,
Right.
but to ask questions, legitimate questions, to have a strategy for each case, to try not to just lump cases, well, this is just another car crash case. This is just another slip and fall. Each case has its own merits and demerits, if you will.
Mm-hmm.
And one of the mistakes I commonly see is that the defense attorney, I don't believe, is reporting the special facts, if you will, whether that would be a particularly sympathetic and credible plaintiff, an injury that might be, an eggshell type injury that you wouldn't necessarily expect, but even the defense experts are conceding is there. And I can't help but suspect, because I'll sometimes get calls, shortly before a trial or at the very end of the case. Well, now my insurance company wants to try and have a second mediation or whatever it may be. And I can't help but suspect that finally, belatedly, there's been a meeting of the minds between the insurance company and their counsel. And the insurance counsel had to answer some tough questions like, well, describe the plaintiff.
Mm-hmm.
Let's talk about the venue we're in. I don't see that factored in enough. Let's talk about the plaintiff's attorney. What's their track record? Do they know what they're doing? Are they gonna take, chicken, and make chicken salad in this
Right.
case, potentially?
Mm-hmm.
And all those need to be factored in. And then the other thing defense counsel doesn't do often enough is correct an insurance adjusting mistake that I see made, namely adjusting a case based on inadmissible evidence. What do I mean by that? You may have a plaintiff who has a felony conviction from 20 years ago, hypothetically.
Right.
Well, that's never, ever going to see the light of day in front of a jury, assuming the plaintiff's kept their nose clean since then, barring extraordinary circumstances under our rules of evidence in pretty much any state, that's not going to be something the jury hears. And so it is a huge error to adjust a case based on evidence the jury will never hear and never see.
Right.
And I have cases where there's something in my client's background that's just not going to come out, but the settlement of the case ends up getting thwarted for a protracted period of time, I can't help but believe, because the insurance company is hanging their hat on something that their counsel should be explaining and admonishing them not to hang their hat on. It's not legitimate. If the jurors don't see it, it's as though it doesn't exist. So you can be upset that, oh, this guy's a felon from 20 years. He robbed a bank 20 years ago, but he's a clean citizen now, and the jurors are never going to hear that.
I would also say, Quentin, as a claims adjuster, your defense counsel should be making reports to the carrier. There is that tripartite ideology where we are paying the defense counsel, but we as the carrier, they don't represent us, right? They do not represent us. The defense counsel is the defense counsel and the attorney of the insured. So, as the adjuster, when we get that report in from defense counsel, we need to be reading that and again, adjusting that claim based off of what the insured's attorney is telling us. If you want to call it the insured's attorney to put your mind in the correct reference spot, call it the insured's attorney. Um, and if and here's the deal, adjusters, the insured's attorney is not going to tell you there is a coverage problem because it is the insured's, the policyholders attorney. So that would be a conflict of interest. And that is a whole nother podcast, a whole nother
Yes.
podcast. But yeah, so you got to read those reports that you're getting from the defense counsel or the insured's attorney to find out how we can settle this claim. Absolutely. Quentin, we are almost out of time. So let me just throw you like maybe a little curveball, a question. You said that you had been an insurance attorney, a defense counsel, whatever. If you were an adjuster, how would you settle a claim? What is the best practices from your point of view as a trial attorney? I know you've listed the 5, but
Right. I think sometimes there gets to be, in the adjuster's eyes, a contest in the sense that I've got to save every penny on every claim. If I can lowball 5 claims this week, then I'm going to get brownie points with my insurance company. And I would submit, and if it's otherwise, if it's different at an insurance company where you work as an adjuster, then maybe you should consider a different insurance company. But rather than adopting as an adjuster a micro analysis where you try and shortchange as to each case, I think more of a macro approach would serve you well. And what do I mean by that? What I mean is, if an insurance company is grading you as an adjuster and you are fairly resolving your claims as a group for a reasonable number, even though you could perhaps pick one of those claims out and say, well, with that particular attorney, if we had fooled around with this longer and been a little more hard-nosed, maybe it could have been adjusted for less. I think you should look at the body of the cases, if you will. And if you resolve meritorious cases early, then I think at a macro level, you will be saving your insurance company money. At a macro level, you should be at least rewarded by your insurance company as an adjuster. And that may involve you going to bat on occasion with your supervisors or whomever to obtain adequate authority at an early juncture. And so passive adjusters who simply say, here's the authority I've been given, those adjusters are not the most effective. I don't believe they're the ones who get rewarded. I have worked with adjusters and against adjusters over the years who have been promoted up the ladder, and consistently, uniformly, those adjusters have adopted the approach I'm advocating, the macro approach. They have not been fearful of someone second guessing them about paying a fair amount on a given individual claim. They're trying to adopt an approach of, am I paying fair amounts on behalf of my insurance company for the claims across the board? And if someone grades me in that fair fashion, how will I rank?
Exactly. I totally 100% agree. And I have said it time and time and time again that if we as insurance carriers settle claims timely and fairly and accurately. And we have a lot of adjusters to handle these sorts of claims. So we're not always putting out fires. We will, as carriers, actually end up, quote unquote, saving money, you know, doing better as a carrier in and of itself. Quentin, thank you so much. Are you speaking anywhere else? Anything you want to promote or let us know about?
Well, Chantal, I am eking out a subsistence living in the rocky soil of the law day in, day out. And I speak quite frequently. Usually it's to lawyer groups, defense lawyers and plaintiffs lawyers. So that's a big part of what I do. And of course, then I have an active, busy trial docket. I handle personal injury cases on behalf of plaintiffs now, not those, and not insurance companies and not corporations that are sued. So that's what I do day in, day out. And I love what I do, but I have a great respect for the adjusters and the defense attorneys who are on the other side of the trenches, if you will. And I try always, as I've said, to treat them with respect. And I hope they do the same with me, and they generally do.
Good, good. Well, I would recommend that everybody reach out and maybe have the carriers have you come out and talk to their adjusters, because again, it's that free flow of information that I think makes us all stronger. Quentin, I want to thank you for your time today.
Thank you, Chantal, for having me on. I really appreciate it.
Thanks. Bye-bye.
Thanks for joining us on the Art of Adjusting podcast, where we talk about life as an insurance adjuster.
If you enjoyed this podcast or this episode, please give us 5 stars and a review. It does help the algorithm pick us up.
Hit that subscribe button real quick and tell all of your adjuster friends to check this out as well. For independent adjusting services, go to www.auton.claims. And for anyone interested in working as an independent liability adjuster, go to the Contact Us tab to join our roster. In the meantime, you can contact me at theartofadjusting.com for consulting and training purposes.